Unit 9 Federal, State, and Local Law Part 1. Learning Objectives. When you have completed this unit, you will be able to accomplish the following. Describe the purpose of the federal fair housing laws and the protections that they offer. Identify other federal regulations related to housing. Overview. The title of this unit may appear to be misleading in that it covers relevant federal laws and only in passing mentions state laws. Federal laws cover everyone in every state. State and city-specific laws cover only a specific state or city. Federal laws set the minimum standard states and cities can add but never delete protections. In many circumstances, individual states are encouraged to pass substantially similar laws, as in the case of fair housing, or state-specific, as with Megan's Law. Federal and state antitrust laws apply to property managers, real estate agents, steel and oil, and most interstate industries. As previously mentioned, managers must be careful that they do not even appear to be setting rents and fees in collusion with other managers. Federal laws have been enacted to prohibit discrimination based on certain defined protected classes when renting or buying real property. Fair Housing Act, and when applying for financing Equal Credit Opportunity Act, whether for a loan to buy a house or for credit for a lease. Most states operate under the federal Lead-Based Paint Hazard Reduction Act. Credit reporting agencies are supervised under the Fair Credit Reporting Act, FCRA. FCRA limits what can be reported, how long information can be retained, and who has access to this information to protect consumer privacy. Federal fair housing laws, as well as state and city fair housing laws, are designed to guarantee everyone an equal opportunity to live wherever they can afford and choose to live. Fair housing laws will not eliminate discrimination, but they do prevent a property manager or owner from arbitrarily rejecting a rental application based on race, color, religion, national origin, sex, familial status, handicap, or other legally protected characteristic. The two significant civil rights laws with which every property manager should be familiar are the Civil Rights Act of 1866 and the Fair Housing Act and its amendments. Civil Rights Act of 1866. Under the Civil Rights Act of 1866, all citizens shall have the same rights as white citizens to inherit, purchase, lease, sell, hold, and convey real and personal property according to the U.S. Supreme Court. Any manner of racial discrimination in real estate is a violation of the Civil Rights Act of 1866. There are no exceptions to this prohibition against discrimination based on race and color. Fair Housing Act, Civil Rights Act of 1968. The Civil Rights Act of 1968 is also known as the Fair Housing Act. The 1968 Act prohibits discrimination in the sale, rental, and financing of buildings and other housing-related transactions based on race, color, and subsequent amendments extending the protections to religion, national origin, sex, family status, and disability. The Civil Rights Act of 1866 was held constitutional by the Supreme Court in the case of Jones v. Alfred H. Mayer Company. The case was decided in June 1968, shortly after the Civil Rights Act of 1968 was passed that did permit racial discrimination in certain circumstances. According to the court, the Civil Rights Act of 1866 prohibits all racial discrimination, private or public, in the sale or rental of real property. A property manager or owner may not, for discriminatory reasons, do any of the following: refuse to show, rent, or negotiate with a person for housing; discriminate in the terms or conditions of a lease; engage in discriminatory advertising; tell potential renters that a property is not available if in fact it is; interfere with, coerce, threaten, or intimidate a person to keep him from taking advantage of the full benefits of the Federal Fair Housing Act. In 2015, a single woman with a 2-year-old child wanted to buy a mobile home from a resident in a mobile home park. The community owners and managers refused to approve the application for residency because the mobile home was located in a portion of the 230-acre park where the owners did not want children. In addition to changing their policies, the owners agreed to pay $45,000 in damages and rent credits to the two people who filed the lawsuit, $45,000 into a fund to compensate other alleged victims, and a $10,000 penalty. Disabilities. The Illinois owner-operator of a HUD-subsidized apartment community agreed to pay $255,000 to settle a suit alleging disability discrimination. The community assigned a mobility-impaired resident to a walk-up third-floor unit and then threatened her with eviction because her daughter stayed in the apartment to help her. She had documentation regarding her disability and the need for a caretaker. A needs assessment will help to determine that 5% of its units are fully accessible, either by constructing new ones or converting existing ones. Domestic violence. Laws allow municipalities to impose fees on owners of single-family dwellings and multifamily properties that call for police assistance too many times. This has had a negative impact on victims of domestic violence. The Federal Violence Against Women Act only protects victims who receive public assistance, such as Section 8. In October 2015, a New Orleans woman was hospitalized due to the wounds she suffered from her abuser. She was told to vacate her apartment when she was released from the hospital. This incident led to the passage of the Louisiana Violence Against Women Act, which bans housing discrimination against survivors of domestic violence. This action influenced the passage of a similar bill in New York State. Protected classes and exemptions. Protected classes are identified as those common characteristics, such as race, color, religion, and national origin, that have been used for discriminatory practices in the past. Originally, these classifications were called minorities, but today, as a reflection of what they really mean, they are referred to as protected classes. Under the Federal Fair Housing Act, as amended, the protected classes include race, color, religion, national origin, sex, familial status, and handicap disability. States and municipalities may add protected classes, but they may never remove any federally protected class. The Act covers most housing, although it does exempt owner-occupied smaller buildings 4 units or less, single-family housing sold or rented without using a real estate agent, and housing that is owned or operated by organizations and private clubs that limit occupancy to members. Under no circumstances is a real estate agent or a property manager permitted to discriminate on behalf of the owner. Blockbusting. Blockbusting is the act of encouraging people to sell or rent by claiming that the entry of a protected class of people into the area will have some negative impact on property values. It is illegal to assert that the presence of certain persons' protected classes will cause property values to decline, that crime and antisocial behavior will increase, or that the quality of schools will decline. A message from the manager or rental agent that the property or neighborhood is undergoing changes because a certain group is moving in may be viewed as blockbusting. Another term for this activity is panic selling. Steering. Property managers should be especially careful to avoid steering, which is the channeling of members of protected classes to buildings or neighborhoods that are already occupied primarily by members of those same classes and away from buildings and neighborhoods occupied primarily by members of other classes. Historically, managers were steering when they put all the white tenants in one building or on one floor and all the Asian Americans, the African Americans, or any non-whites in another building or floor. A more current example of steering is congregating all families with children in one building or on one floor away from tenants without children. Steering may also occur when the manager tells the prospect that there is no vacancy when, in fact, there is a vacancy. This misstatement, which is illegal when it is made on the basis of any of the protected categories, steers the prospect away from the manager's building. Steering can be very subtle and difficult to detect, and it can also be unintentional. For instance, a property manager may not even be aware of discriminatory assumptions, as when a manager believes that an Asian American tenant would automatically wish to live with other Asian Americans. However, whether intentional or not, such behavior is unlawful. The law is clear that even if there were no intent to discriminate, if discrimination occurs, there is a violation. In March 2011, a Washington community agreed to pay $110,000 in damages and civil penalties to settle allegations that it treated applicants from India differently than other tenants and did not show them available units in one of the 5 buildings. It also discouraged African Americans, Latin Americans, and families with children. Of the award, $85,000 went to establish a settlement fund for tenants and prospective tenants harmed by the practices of the manager, and $25,000 was paid as a civil penalty to the United States. Also, the owners provide fair housing training to their employees and maintain a common recreational area for all tenants, including children. U.S. versus Summerhill Place. Equal housing poster. Failure to post the equal housing opportunity poster may be considered prima facie evidence of discrimination. A copy of the poster can be obtained from the U.S. Department of Housing and Urban Development (HUD). The Equal Housing logo should also be used in all display advertising and printed materials. Discriminatory advertising. Discriminatory advertising includes using references to race, color, religion, sex, national origin, familial status, or handicap in any advertising. Property managers should avoid using terms that imply integrated or segregated neighborhoods or buildings. It is also unlawful to use human models in advertising to indicate exclusiveness based on race, color, religion, sex, handicap, familial status, or national origin. Advertising should describe the property, not the other tenants and the landlord. Words should be inclusive, not exclusive. For example, an ad specifying a certain number of people for a rental unit could be interpreted as discriminating against children. On the other hand, great for a family would be acceptable. Great for active people may indicate that a handicapped person is not wanted. Likewise, must be employed may discriminate against an unemployed handicapped person who has another source of income. Better and legal phrases include verifiable income or credit check required. 13 Oregon newspapers received notice from the U.S. Department of Housing and Urban Development of 130 alleged violations. If all complaints had been upheld, hundreds of thousands of dollars in fines would have been levied. All of the newspapers thought that their advertising was legal and correct. From that experience, the Oregon Newspaper Publishers Association authored an instructional kit, the Fair Housing Advertising Manual. Property managers who write and place ads should obtain a copy of this self-instructional manual. The newspapers that accept the ads must ascertain that the ads contain legal information. Violations continue today. In May of 2011, an online classified publishing and local internet advertising company agreed to pay $15,000 to settle claims that it violated the Fair Housing Act when it allowed advertisers to post no children, no kids. The company also agreed to change the way its websites filter discriminatory language. A 2011 study published in the Indiana Law Review found there are actually very few ads that discriminate on race, religion, or ethnicity. Most discriminatory online housing ads are almost always posted by people seeking roommates and are primarily based on familial status. Fair Housing Amendments of 1988. The Fair Housing Amendments of 1988 added two of the protected classes previously mentioned. Family status. The minimum for establishing familial status is the presence of at least one individual in the family who is younger than 18, or the presence of a pregnant woman, or one who has or is obtaining custody of children. Landlords may no longer refuse to rent to families with children. Condominiums and cooperatives may not exclude children from living in their communities unless the community meets specific HUD requirements to qualify as elderly or near elderly. Property managers must ensure policies and procedures apply equally to everyone, and the building rules, however fair they may sound, may not be implemented with only children in mind. Placing families with children in one building or on one designated floor, or imposing occupancy standards that place undue burdens on families with children, such as one person per bedroom, are also unlawful. The courts do not look kindly on rules that unduly restrict children's activities or managers who turn away apartment seekers with children. In November 2012, a Florida Homeowners Association and its former management company were sued by the Justice Department because they threatened to evict a couple and their 6 minor children from the 4-bedroom townhome they were renting. The association's occupancy policy allowed only 6 individuals in the 4-bedroom unit, as well as equally restrictive limitations for the 2- and 3-bedroom units. The association restrictions were more stringent than those of the county, which allows up to 11 residents in a 4-bedroom home. While there is no federal occupancy law, the U.S. Department of Housing and Urban Development has indicated that occupancy standards more restrictive than 2 persons per bedroom are too restrictive and unfairly impact families with children. In 1991, then Attorney General Frank Keating wrote a memorandum outlining the legitimacy of 2 persons per bedroom, taking into account the size of the rooms, that while not called bedrooms could be used as such local building codes, and making exceptions for infants. HUD adopted the Keating Memorandum as the official guidelines for occupancy standards. In 1998, HUD introduced other factors to consider, such as the design and size of rooms, ages of children, and state and local ordinances concerning occupancy. Exemption to familial status. An exemption to the prohibition against excluding families with children is housing that falls into the housing for older persons category. The definition for housing for older persons includes any of the following: housing that is provided by a state or federal program designed to assist older persons. Housing that is intended for and solely occupied by those 62 years or older. Housing designed for older persons in which at least 80% of the housing is occupied by at least one person who is aged 55 or older. Housing for Older Persons Act, HOPA. The 1995 Housing for Older Persons Act, HOPA, amended the Civil Rights Act of 1968. A HOPA community can market itself as 55 provided they maintain occupancy of 80% or more of older residents. While the communities often allow younger than 19, usually children or grandchildren, to come for a visit, such communities are usually careful about ensuring that those younger than 19 are living in a household that has at least one occupant 55 and older. Community bylaws have a great deal of latitude, and so long as the rules are consistent, they are enforceable. Developers are challenged, though, because sometimes the older occupants are not happy about finding young people in their community. Managers should recognize that state and local laws can be more stringent than the federal law. A handicap disability. Also protected are those with a disability. Although the Fair Housing Act uses the term handicap, today the generally accepted term is a person with a disability. HUD defines a person with a disability as any person who has a physical or mental impairment that substantially limits one or more major life activities, has a record of such impairment, or is regarded as having such impairment. Protected are those infected with the human immunodeficiency virus HIV, as well as those who are physically disabled, developmentally disabled, or chronically mentally ill. Alcohol and drug addicts who are in a medically based program where Alcoholics Anonymous or Narcotics Anonymous may not be discriminated against. Generally, landlords are not required to modify their units built before March 13, 1991, to fit the special needs of those with a disability, although they must let such tenants make any necessary and reasonable modifications at the tenant's expense. These tenants may be required to return the premises to their original condition at the end of the lease term. However, any newly constructed multifamily building with 4 or more units that was ready for occupancy after March 1991 must allow access and use by handicapped persons, for example, by including wheelchair ramps and elevators. It is not sufficient to build to the local code. The federal guidelines mandate design minimums that must be followed, even if the local codes differ. Not all architects are aware of the requirements, and building to ADA code does not always satisfy accessibility requirements for private dwellings covered by the Federal Fair Housing Act. Court case. The Justice Department filed a lawsuit against the owners, developers, and design professionals who constructed 9 multifamily housing complexes in Mississippi, Louisiana, and Tennessee involving more than 2,000 apartments, of which 800 are ground floor units. Among a litany of complaints, the properties have pedestrian routes, light switches, electrical outlets, thermostats, kitchens, and bathrooms that are not accessible to persons with disabilities. The DOJ is seeking retrofitting and monetary damages to those harmed by the discriminatory practices. Reasonable accommodations may include a change in rules, regulations, policies, or services that could include allowing a service animal even though the property has a no-pet policy, allowing for accessible parking spaces and apartment transfers. Reasonable modifications include physical or structural changes to the apartment or common areas, such as adding grab bars to showers or toilets, installing ramps at curbing end, removing or lowering cabinets for access from a wheelchair. Property managers should be aware of the different requirements of the ADA, A, which applies to commercial properties, and the fair housing laws, which primarily pertain to residential properties. Often the type of property determines who is required to pay for the modifications. Service animals. The Fair Housing Act and the regulations of the HUD allow assistance animals, that is, animals that work, provide assistance, or performs tasks for the benefit of a person with a disability, or provide emotional support that alleviates symptoms of effects of a person's disability. Types of animals vary and are not required to meet any training standards. When presented with a request for an animal in a no-pet situation, the manager is permitted to ask 2 questions. Does the person who is asking have a disability, a physical or mental impairment that substantially limits one or more major life activities? Does the person making the request have a disability-related need for an assistance animal? If the answer is yes to both of the questions, then the housing provider is required to modify or provide an exception to a no-pets rule. No proof of training is required. Court cases. New Mexico owner and the manager of a rental property agreed to pay $200,000 because they discriminated against a tenant who asked to make reasonable modifications. 2 years after the tenant moved in, he became disabled and needed to use a wheelchair. Although he planned to pay for modifications to the rental home and assured the owner that he would restore the property when he left, the owner and manager refused to allow him to make the modifications, and they proceeded to evict him for making the request. The owner must implement a policy and procedure for dealing with such requests in the future and must report to the government for the next 3 years. Puerto Rico Condominium Association agreed to a $1 million settlement after it refused to repair any of the 4 elevators in one of its 2 towers. The person with a mobility disability filed suit when she had to walk 4 flights of stairs getting to and from her home. She also alleged that the activities of other residents with mobility disabilities were limited because of the lack of elevators using credit reports. Note that fair housing laws require a management firm to utilize credit reports for all applicants if it is going to use them at all. In other words, a manager may not require one particular applicant to pass a credit report check if this is not required of all applicants. Also, the 1988 Fair Housing Amendments Act prohibits charging families with children and those with handicaps higher deposits or higher rents than other tenants. Testers. Discriminatory practices are often difficult to prove, so fair housing advocacy groups often use testers to gather evidence for fair housing complaints. 2 or more testers might represent themselves to landlords as prospective tenants and then take note of any differences in treatment. For example, both a white tester and a non-white tester may seek an apartment in the same building. If the white tester is shown the apartment but the non-white tester is told that no units are available, this information will provide very convincing evidence of discrimination. The evidence gathered by testers, such as tape-recorded conversations between property owners and the testers, has proved to be invaluable in determining the presence of discriminatory behavior. Key policy. However, it is important to remember that anyone may be a tester, not just a person who has been specially trained. As a matter of practice, managers should treat everyone equally, without exception, without regard to race, color, religion, national origin, sex, familial status, or handicap. Filing a complaint. A complaint may be filed directly with HUD, or more commonly with a local city or state human rights agency. Initially, attempts to bring the parties together will be made. This is called the conciliation period. If that fails, either the case will be heard by an administrative law judge or as a civil action in the appropriate U.S. district or state court. The burden of proof falls on the complainant, who must prove that the discrimination occurred. Conciliation relief. When possible, conciliation attempts to provide any or all of the following: monetary relief in the form of damages, including damages caused by humiliation and embarrassment, plus attorney fees. Other equitable relief, possibly including access to the dwelling or comparable dwelling injunctive relief to eliminate the discriminatory practice affecting the aggrieved person. Civil penalties. Not every complaint can be resolved in the conciliation process. When cases end up in court, fines may be levied ranging to amounts more than $100,000 for multiple violations. HUD adjusts the penalty amounts periodically. These civil penalties are paid directly to the United States, not to the aggrieved person. Actual damages and punitive damages. An aggrieved person can obtain an award of actual damages and injunctive relief in either an administrative or federal court. An administrative law judge can also impose the civil penalties mentioned above. In a court action, however, a judge or jury can award unlimited punitive damages to the aggrieved party. Also, the prevailing party may be awarded reasonable attorney's fees and costs. Statute of limitations. The federal law permits a complaint to be filed with HUD up to 1 year after the alleged violation. The case must be filed in court within 2 years of the alleged violation. Note that these are the federal guidelines that often act as a safety net inasmuch as most states and cities have imposed briefer limitations. Avoiding fair housing violations. Designate someone in the office to be a fair housing officer to be responsible for training, keeping up with current fair housing laws, answering employees' questions, and keeping track of compliance with office fair housing policies. Discuss fair housing objectives and requirements on a regular basis in staff meetings. Make sure that tenant selection criteria is objective, relevant to fulfilling lease obligations, and applied uniformly. Appropriate criteria include the tenant's rent-to-income ratio, credit record, and rent payment pattern. Keep detailed, comprehensive records of each prospect and inquiry. Amendments are fairly broad in that the definition of handicap includes a mental as well as a physical impairment. Recovering drug addicts, alcoholics, and people with AIDS are included in the definition of handicap. Ensure that policy and procedures provide consistent services to all residences, comply with the law, and are effectively communicated to staff and tenants. Role of the property manager. The manager can contact the local human rights organization for additional state and city information. Every attempt to remain current with the laws should be made, including attending seminars at trade shows and taking continuing education classes. The manager should constantly stress compliance at every opportunity with every employee and keep copies on file of any training sessions held. Other regulations. Learning objective: identify other federal regulations related to housing. Antitrust laws. The purpose of federal antitrust laws, particularly Sherman Antitrust Act, is to promote competition in an open marketplace. Price fixing limits this competition and damages the consumer because the consumer no longer has choices. A property manager should be quite careful not to violate this law. Each manager has the right to set rental and management fees according to the needs and expenses of the property. In order to determine market rates, managers want to have an idea of what is being charged for similar rental units in the area. However, managers should not directly call their competition to ask what the consumer is being charged and then discuss those rental rates. There is a fine line between simply gathering information and appearing to conspire to fix prices. The safest way to obtain competitive information is to go out and get it, a practice known as shopping the competition. Either the manager or a leasing agent in training can be the shopper, appearing as a well-qualified typical prospect for a particular unit. This can be both a training device and a method of obtaining competitive information. While looking at the unit and by asking pertinent questions, the shopper will learn not only the fees but also the amenities, both of which affect leasing values. These anonymous visits take more time but are more effective and less likely to be misunderstood in the long run. Any suspicion of price fixing between management companies or managers can result in civil and criminal penalties. If the courts were to determine that price fixing had occurred, the managers could spend time in a federal penitentiary in addition to paying huge fines. Managers should never discuss their rental rates with anyone other than the owner of the property and the tenants they are charging. Americans with Disabilities Act. The Americans with Disabilities Act AD has directed that no person may be discriminated against on the basis of disability in employment, transportation, public accommodations, telecommunications, and in state and local government services. The ADA requires any business or other facility open to the public to be accessible by the handicapped. Not only must physical barriers be removed whenever practical, but policies and standards must be changed to make businesses more accessible. Note that discrimination against the disabled in the context of residential housing is covered by the Federal Fair Housing Act, previously discussed. Additionally, a management company employing 15 or more employees may not discriminate when hiring. An employer may not ask applicants if they have a disability or inquire into the nature or severity of a disability. Employers may ask if the applicant can perform the essential job functions as described. Disability defined. A disability is defined as any physical or mental impairment that substantially limits one or more of the individual's major life activities, including caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, and working. What are requirements? When readily achievable, removal of structural architectural barriers and communication barriers to make goods and services accessible to individuals with disabilities. Other requirements include providing auxiliary aids and services to ensure that no individual with a disability is excluded, denied services, segregated, or otherwise treated differently than other individuals unless to do so would fundamentally alter the nature of the good, service, or accommodations, or result in an undue burden. All commercial structures designed and constructed for first occupancy after January 26, 1993 must comply with the law. The only exception to providing access by individuals with disabilities to new or remodeled facilities occurs when the nature or purpose of the structure prevents any accommodations from being made, which is a difficult requirement to meet. Existing barriers must be removed whenever this can be done at a reasonable cost. Following are some examples of how this can be done. A building with no elevator may have to install a buzzer or intercom at street level so that customers of a second-floor business may obtain assistance. A payphone may have to be lowered to make it accessible to someone in a wheelchair. Automatic entry doors may have to be installed. Grab bars may have to be added to restroom stalls, which may also have to be made larger. Ramps must be installed to outside doors. Raised letters and braille markings must be added to elevator buttons. The direction in which doors open may have to be reversed. Megan's Law. 7-year-old Megan Conca of Hamilton, New Jersey, was sexually assaulted and murdered in July 1994 by a convicted sex offender who had moved into the neighborhood unbeknownst to Megan's parents. The law was named in her memory and requires that information about certain sex offenders be released to the general public. After New Jersey passed the first Megan's Law, the Congress enacted a federal version as part of the Federal Violent Crime Control and Law Enforcement Act in 1996. Megan's laws have been challenged as unconstitutional in several states, but none of the challenges have invalidated any state Megan's Law. Reporting requirements. Prison officials are required to inform convicted sex offenders of their obligation to register with state law enforcement authorities and to re-register if they move to another state. The state agencies are in turn required to inform local law enforcement authorities, typically the local police department, of convicted sex offenders who reside in their jurisdiction. Also, the agencies are to inform the FBI about these addresses. Local law enforcement agencies are then permitted to release collected information as necessary to protect the public or for any purpose permitted under the laws of the state. Divulging this information varies from state to state, inasmuch as states were permitted to choose one of the following three options: notification to all, putting all names on the internet; notification to those most at risk, schools, daycare centers; individual and address specific when specifically asked about each address. State laws and the property manager. Property managers may wish to institute a criminal background check as part of the hiring process for employees who will have keys and access to apartments, particularly if access is not always supervised. Consulting the sex offender registry open to the public should be part of the pre-employment checklist. Owners and managers should do everything possible so the key to a resident's home does not end up in the hands of a registered sex offender. In other liability cases, courts have not expected owners and managers to do everything possible to secure a property. Instead, they have looked at reasonable measures taken and reasonable standards of care. As state laws vary, the property manager must become familiar with the local requirements and should consult with a local attorney for specific guidance on how much information the manager is responsible for relaying to a tenant. The answer will no doubt depend upon the manager's actual knowledge about the presence of a convicted sex offender, the particular provisions of the applicable state Megan's Law, and whether the tenant questions the manager about the presence of convicted sex offenders. Sexual harassment. Claims of sexual harassment by employees concern every employer. It is important for the property manager to put into place a clear written policy against sexual harassment, provide an employee-friendly procedure for investigating complaints, and conduct thorough and unbiased investigations that lead quickly to corrective action. Moreover, the multifamily housing industry faces two additional concerns: tenants' claims of harassment by owners and management employees, and claims against management for behavior between tenants that may constitute sexual harassment. Quid pro quo cases are the easiest to define. That is, lease terms may not be conditioned on submitting to sexual demands. It is hard to prove that the act was not pervasive and persistent. Defense on these grounds is risky, and owners and managers face the risk of huge awards and attorneys' fees. Court cases. The policy should include a zero-tolerance written policy for tenants as well. This policy should be publicized to every tenant, and a means by which tenants can complain should be indicated. If a complaint is raised, property managers should act swiftly when investigation indicates a problem. Employees should understand that what appears to be personal matters between tenants could turn into liability claims against the company. The owner of dozens of residential rental properties in Bakersfield, California, agreed to pay $2 million to 25 individuals that he sexually harassed and the maximum $55,000 civil penalty. The victims assert that he made unwelcome sexual comments and more, including retaliating against the women who refused his sexual advances. After more than 30 years in real estate, the owner may no longer manage his own properties, must hire an independent manager, and may not have contact with current and future residents. U.S. versus Sorensen. A Cincinnati landlord was ordered to pay $800,000 to 14 victims of his sexual harassment and a $55,000 penalty to the United States. He entered the apartments of female tenants without permission, offered housing benefits in exchange for sexual favors, and took adverse actions against them when they refused. He is prohibited from any further such acts, and he must hire an independent management company to manage any of his current properties and any that he might acquire in the future. Equal Credit Opportunity Act. By the early 1970s, it was apparent that lenders and other creditors were using a woman's sex and marital status as a means to deny her credit instead of basing the decision on business terms such as adequacy of income and lack of existing debt. The Equal Credit Opportunity Act was passed in 1974 to open borrowing doors to women. This paved the way for other complaints of discrimination, and shortly thereafter, the ECOA was amended to include a total of 8 protected classes. Today, the ECOA prohibits denying a person a loan simply because of race, color, religion, national origin, sex, marital status, age, and receipt of income from public assistance. The law applies to applications to rent a dwelling, inasmuch as the lease is considered an extension of credit. Evaluating lease applications. The property manager must evaluate each lease application on the same terms. The manager must base the decision to lease extend credit on sound financial reasons. Generally, the applicant must show proof of income, submit to a credit check, and not be excessively encumbered by debt. The manager may deny credit for many reasons, including the following: unverifiable credit references, insufficient income, temporary or irregular employment, insufficient length of employment, excessive debt, too many unpaid bills, prohibited requests. It may seem humorous now, but it was not long ago that creditors and landlords required information about an applicant's birth control practices, marital status, single, divorced, widowed, married, race, color, religion, or national origin. Lenders may not ask for this information because it is not relevant to the loan process. Nevertheless, applicants will be asked their race, color, and national origin on many loan applications. This information is asked in order to assist monitoring practices by governmental agencies. In fact, if the applicant does not answer the questions, the lender may be required to fill in the blanks based on what the lender sees and interprets. It is to everyone's benefit to comply, remembering that it is illegal to use this information to deny a loan. Penalties for violating the ECOA are severe. Civil liability for damages includes up to $10,000 in addition to punitive damages. The aggrieved parties who file a class action suit in federal court can be awarded up to $500,000 or 1% of the creditor's net worth. The court can also award court costs and reasonable attorney's fees to the aggrieved applicant. Property manager's responsibilities. The manager should use the same lease application form for every applicant. If the manager is going to require a credit report from one applicant, it should be required of all applicants. The manager should be consistent when considering income and acceptable debt. Many managers do not rely on credit reports only. In order to verify income and timely rent payments, they call previous owners or managers, ask to see W-2 forms and paycheck stubs, or request copies of canceled checks to verify recent rent payments. The guiding principle remains: what is done for one must be done for all. Under ECOA, applicants who are rejected for credit have the right to see their entire file in order to determine if they have been denied credit because of a protected category. Fair Credit Reporting Act. Historical background. The Fair Credit Reporting Act, FCRA, became law in 1971 and has been amended several times. The intent of the law is to ensure that the data contained in credit reports are correct. The law regulates consumer reporting agencies, those who use credit reports, and those who provide information to the consumer reporting agencies. Landlords and property managers use this information and often contribute to consumer files. Fair and Accurate Credit Transactions Act, FACTA. The Fair and Accurate Credit Transactions Act, FACTA, was passed in 2003 to allow consumers access to a free copy of their credit report once a year. The free report can be requested by telephone, mail, or the government-authorized website annualcreditreport.com. Consumers have easy access to their reports and can identify and dispute inaccurate information. Enforcement by the Consumer Financial Protection Bureau, CFPB. Since its creation in 2011, the Consumer Financial Protection Bureau, CFPB, sorts and filters individual complaints by product, issue, company, state, and more. The top 3 most common complaints are about mortgages, debt collection, and credit reporting, but it also compiles information about credit cards, bank accounts, private student loans, payday loans, prepaid cards, money transfers, and much more. Purpose of consumer credit reporting agencies. While lenders know the payment histories of their own customers, they have no idea of how an applicant has treated other creditors. The basic concept behind these requests is this: if an applicant has made timely and full payments to another creditor, then this creditor may presume that the applicant will do the same for this loan. On the other hand, if the applicant has been negligent in making payments or is consistently late, the lender may turn down the applicant, fearing that the applicant might not repay the lender. Past history can be as important as current status. Credit report information. A credit report is a history of how a person pays bills. A report generally includes identifying information, a list of current and previous credit cards and loans, public record entries and collection activity, if any, and a list of creditors who have inquired and reviewed the credit file. The report may include information about past due accounts and the number of payments currently due and whether these payments have been made on time. Property managers often enter information about delinquent tenants and those who have skipped leaving behind dirty apartments and unpaid leases. Credit reports do not contain any information not related to the lending process, such as medical information, driving records, checking, savings, or brokerage accounts, insurance policies, or comments related to job performance. Consumers have a right to obtain a copy of their reports and should do so at regular intervals to make sure that no erroneous information has been entered. If the consumer has been denied credit, she can receive a free report within 60 days of the denial upon request. Other consumers should contact their local credit bureau for a copy. Credit report errors. A recent study by the Federal Trade Commission analyzed credit reports from the 3 major credit bureaus and found that about 25% of the consumers had at least one potentially material error in at least one of the reports. Such errors included the number of credit card or mortgage payments that the consumer was supposed to have missed, or the number of loans that were sent to collection agencies. The FCRA entitles consumers to challenge, in writing, the accuracy of any information in their reports. The information must be verified in a timely manner and then certified as correct, modified, or deleted. If the verifying party does not do so within 30 days, the information must be deleted. The consumer must be notified about the change within 30 days. However, should the dispute still exist, the consumer has the right to add up to 100 words of explanation that will be reported every time the disputed information is reported. Information on file. Accurate though adverse information will stay on file for 7 years, except for bankruptcies which stay for 10 years. Usually, completed Chapter 13 bankruptcies are deleted after 7 years. Just because a delinquent account has been brought up to date or paid off does not mean that it is deleted from the report, however. Creditors will consider the paid collection and late payment notation as part of the overall payment history when determining whether they will grant credit. Persons seeing the credit report. Landlords are increasingly turning to credit reports as a means to determine financial responsibility on the part of the lease applicant. This is the only reason why landlords should look at the report. The FCR provides civil and criminal penalties in the event a credit report is obtained illegally or used for any other purpose. Consumer reporting agencies and consumers have a civil cause of action against those who illegally access reports. Property managers should thoroughly review reporting procedures with only those in the office who should see the report. Emphasis should be made about the confidentiality of such reports. Rejection based on credit report. In the past, if a property manager denied an application based on the applicant's credit report, only the name and address of the credit agency needed to be given to rejected applicant. After September 30th, 1997, however, a rejection letter must include the following: the name, address, and phone number of all consumer credit reporting agencies that provided information, and notice that the credit agencies only provide information about credit history, take no part in the decision process, and cannot provide an explanation for the decision. Explain the applicant's right to obtain a free copy of the credit report, dispute its accuracy, and provide a consumer statement describing the applicant's position. Application for criminal checks. Landlords or employers may run a criminal background report if an employee, prospective employee, or prospective tenant consents in writing. If the information is negative and the manager does not want to hire this person at least in part because of this report, the manager must inform the applicant and provide a copy of the report. To be consistent, the manager must ask for permission to run the reports on every prospective job applicant. One should not hire just on appearances anyway. If the manager neglects to check out references, the manager may hire an unfit person and could be found liable for negligent hiring. The manager could face a lawsuit claiming that the manager failed to make reasonable inquiry into the applicant's background, that a reasonable inquiry would have discovered potential problems, or that the manager knew or should have known that this person was a risk to others. As many employees have easy access to keys to many properties, every property manager should carefully consider all references. In today's world, spending an extra few bucks to run a criminal check could be a wise investment. Uniform Electronic Transactions Act spam electronic contracting. Technology and the internet have significantly changed the way in which real estate transactions are performed. Electronic contracting is a growing pan of real estate practice because it quickly and efficiently integrates information in a real estate transaction between clients, lenders, and title and closing agents. The transactions are conducted through email or fax and can save both time and money. Two federal acts govern electronic contracting: the Uniform Electronic Transactions Act and the Electronic Signatures in Global and National Commerce Act, e-Sign. The law sets forth basic rules for entering an enforceable contract using electronic means. The primary purpose of UEDA is to remove barriers in electronic commerce that would otherwise prevent enforceability of contracts. UEDA's 4 key provisions are the following. A contract cannot be denied its legal effect just because an electronic record was used. A record or signature cannot be denied its legal effect just because it is in an electronic format. If a state's law requires a signature on a contract, an electronic signature is sufficient. The Electronic Signatures in Global and National Commerce Act, e-Sign, was passed by Congress in 2000. E-Sign functions as the electronic transactions law in states that have not enacted UEDA, and some sections of e-Sign apply to states that have enacted UEDA. The purpose of e-Sign is to make contracts including signatures and records legally enforceable, regardless of the medium in which they are created. Prohibited communications. Businesses must comply with a variety of prohibitions intended to protect consumers from the intrusions of unwanted communications. In 2003, federal do not call legislation was signed into law, and the Do Not Call Improvement Act of 2007 further strengthened the protections available to consumers. Real estate professionals must comply with the provisions of the National Do Not Call Registry, which is managed by the Federal Trade Commission, FTC. The registry is a list of telephone numbers from consumers who have indicated their preference to limit the telemarketing calls they receive. The registry applies to any plan, program, or campaign to sell goods or services through interstate phone calls. The registry does not limit calls by political organizations, charities, collection agencies, or telephone surveyors. The law does apply to a for-profit telemarketer, even if the telemarketer is working for a nonprofit organization. Telemarketers and sellers are required to search the registry at least once every 31 days and drop registered consumer phone numbers from their call lists. Normal business relationships are still possible. Real estate professionals may call consumers with whom they have an established business relationship for up to 18 months after the consumer's last purchase, delivery, or payment, even if the consumer is listed on the National Do Not Call Registry. Also, a real estate professional may call a consumer for up to 3 months after the consumer makes an inquiry or submits an application. Even though the federal legislation applies to interstate telephone calls, most states also have do not call rules or regulations that apply to in-state calls. It is important to keep up to date with state laws regarding do not call policies, as well as the national law. Similar federal and state laws apply to marketing and business communications by fax and email. The Telephone Consumer Protection Act, Junk Fax Prevention Act, and rules of the Federal Communications Commission, FCC, prohibit most unsolicited fax advertisements. Junk email spam are prohibited by the Federal Controlling the Assault of Non-Solicited Pornography and Marketing Act of 2003, known as the CAN-SPAM Act. An important feature of this law, which applies to commercial electronic mail messages, is that email solicitations must include a means by which the recipient can unsubscribe from future messages. The most recent restrictions on the use of the Internet, including mobile apps and ad networks, went into effect on July 1, 2013, as part of the ongoing Children's Online Privacy Protection Act, COPPA. COPPA requires the posting of a privacy policy and limits the personal information that can be collected from children younger than 13, even if a website or app is directed toward a general audience. Service Members Civil Relief Act. Congress passed the Service Members Civil Relief Act, SCRA, in 2003, but its legislative roots date to at least the Civil War. Affecting many active duty military personnel, the SCRA allows service members to postpone or suspend certain civil obligations such as credit card debt, trials, and taxes. The law is intended to relieve stress on service members so they can devote their full attention to duty. As such, real estate issues are a major component of the SCRA, which may offer relief to service members who are delinquent or burdened by mortgage payments or may even be facing eviction. Lead-Based Paint Hazard Reduction Act. Lead is a heavy, soft, malleable, blue-gray metal found as a natural ore or as a byproduct of smelting silver. Once removed from the ground, lead is part of the human environment forever. Lead was banned from gasoline in the early 1970s and from paint in 1978. Effects of lead on humans. Lead poisoning is not spread from person to person, but rather through ingesting and retaining high concentrations of lead. Lead is very slowly eliminated through the kidneys and gastrointestinal tract. Lead has no known use in the body. Although high concentrations will affect anyone, children younger than 6 are particularly vulnerable. Lead poisoning is discovered through a blood test. Excessive lead can cause major health problems in children by damaging the child's brain, nervous system, kidneys, hearing, or coordination, causing headaches and behavior problems and affecting learning. Sources for lead exposure. Major sources of exposure include paint, surface dust and soil, drinking water, air and food. House and soil dust comes from the weathering and chipping of lead-based paint. Renovation efforts, such as scraping or sanding, help spread the dust, and it is easily carried by many sources: clothing, tools, pets, shoes, and so on. Raising and lowering windows disturbs the paint and also rubs the lead ballasts. Chipping and peeling lead paint in the house can become airborne and widely spread through the use of an ordinary vacuum cleaner. Airborne lead lands on toys, even fingers, which children tend to touch, suck on, and chew. Target housing. Any housing constructed prior to 1978 is affected. Exempt is housing for the elderly or persons with disabilities, unless children who are younger than 6 will be living in such a dwelling. Any zero-bedroom dwelling, no separation between living, eating, and sleeping areas is affected. Exemptions also include rental property that has been inspected and certified to be free of lead-based paint, property leased for fewer than 100 days per year property, where renewal or extension cannot occur, summer rentals, and in cases where an existing lease is renewed once proper disclosure has been made. Required disclosures. There are 3 basic requirements for landlords and managers. Disclose to the tenant the presence of any known lead-based paint hazards. Provide tenants with copies of any available records or reports pertaining to the presence of lead-based paint and hazards. Give the tenant a copy of the EPA Lead Hazard Information Pamphlet Protecting Your Family from Lead in Your Home, available from epa.gov in English, Spanish, Vietnamese, Russian, Arabic, and Somali. Lead-based paint disclosure. Penalties for non-disclosure. There are 11 possible violations per lease. Failure to comply with these regulations could result in civil fines up to $16,000 per violation. A violator also may be assessed for triple the damages suffered by the tenant or the buyer, in addition to any criminal fines and imprisonment. In August 2014, a St. Petersburg, Florida landlord was fined $25,000 per day for failing to properly inform tenants about the potential of lead-based paint in their apartments through disclosure and warning statements, and failing to make them aware of records or reports that would alert them. He also agreed to pay a fine of $50,000 to the EPA for costs incurred by the EPA as it removed and replaced lead-contaminated soil. He also faces possible imprisonment up to 1 year. Monitoring files. Both the HUD and the EPA have awarded grants to advocacy groups to increase awareness of the requirements of Title X. Moreover, a special $50 million fund has been created at the DOJ for stepped-up enforcement of environmental violations. Management responsibilities. But the public is becoming increasingly aware of the hazards of lead, and more blood testing is being done in young children. Awareness will result in increased testing for compliance with the disclosure notices, just as testing for fair housing is done. Each regional EPA office has quarterly quotas to inspect office files. Officials will be randomly checking rental office files. If a complaint is received about non-disclosure, that property goes to the top of the list. In March 2013, a Cambridge, Massachusetts, owner of a 60-unit apartment building refused to remove lead hazards required in Massachusetts from an apartment he rented to a family with a small child. Additionally, he increased the monthly rent, refused rental payments, refused to renew their lease, and refused to abate the lead hazards. In addition to having to pay $25,000, the owner must relocate the family and remove the lead from the current apartment. The owner previously had to pay $29,000 on a judgment obtained by the state and local authorities. Key policy. The manager should develop an operations and maintenance plan for any lead-based paint on the property. Such a plan may include representative dust testing to verify that cleanup practices following routine maintenance procedures are sufficient to eliminate lead dust hazards. Tenants should be aware that routine housekeeping on their part is essential to controlling any lead-containing dust that may be tracked or blown into their apartments from outside. Finally, the tenants should be encouraged to report any situation involving damaged or deteriorating painted surfaces. Uniform Residential Landlord and Tenant Act. The Uniform Residential Landlord and Tenant Act, drafted in 1972 by the National Conference of Commissioners on Uniform State Laws, was designed to standardize and regulate the relationship between property owners and their tenants. Variations of the Uniform Act have been incorporated into the statutes of several states, so property managers should study and keep current with variations and modifications found in state and local laws. The Act covers only residential property. Each of the states that have adopted the Uniform Act have variations to the basic law, so the manager should carefully read the law and look for specific answers to the following Uniform Act provisions. No abrogation of rights. Under the Act, leases may not contain a judgment clause, a clause in which the tenant waives any rights or remedies, or any clause contravening the Act. The tenant may not sign away his rights. No retaliation. If a tenant makes a complaint to the Health Department, Fair Housing Board, or any other governing authority, the landlord is generally prohibited from summarily raising that tenant's rent or any other type of response that can be interpreted as retaliation or punishment. Fair dealings. If a legal dispute arises between owner and tenant, the court may refuse to enforce all or part of a lease that it finds grossly unfair. The Act further stipulates that the owner and tenant should make a joint inventory detailing the condition of the premises and all rented furnishings and appliances within 5 days after the tenant takes possession. Both parties should sign and retain a copy of this inventory. State from period to period. One of the more notable provisions of the Uniform Residential Landlord and Tenant Act is that unless otherwise specified, a tenant is considered to have an estate from period to period. A tenant who pays weekly rent holds tenancy from week to week, whereas all others hold an estate from month to month. Effects of unsigned leases. If the owner or tenant signs and delivers a written lease, and if either party pays or accepts rent, the lease is often considered binding, even without the other party's signature. The Act also establishes standard lease termination procedures. Security deposits. Specific guidelines are established regarding security deposits, which have been one of the largest single sources of disagreement between owners and tenants. State law determines the circumstances under which the security deposit will be made. Neither the tenant nor the manager should consider the security deposit the last month's rent. It is a deposit to be used for any damages. What to do with the security deposit and the interest it earns varies from state to state. Sometimes it may be forwarded to the owner. In other states, it must be deposited in a trust or escrow account, often within the state where the property is located. Some states require that deposits are made into interest-bearing accounts, others do not. The manager must learn local requirements. Many states specify exactly what the landlord may do with the deposit at the end of the tenancy. Generally, the landlord may deduct money for unpaid rent and damage to the property. However, usually the landlord must itemize the deductions within a certain time frame, explaining why all the deposit is not being returned. Failure to do so may result in having to refund up to 3 times the amount wrongfully withheld. In some states, the tenant is required to ask for the security deposit at the end of the term. Owner's responsibilities. Although the rental agreement may limit the owner's liability for fire, theft, and damage in common areas, the Act clearly establishes the owner's responsibility for keeping the premises safe and fit for habitation. The Act authorizes the owner to establish building rules concerning use and occupancy as long as they are reasonable and equitably enforced. These rules must be in writing, and the tenant must agree to them. Owner's right to re-enter. The owner is given the right to enter rental units after giving reasonable notice to inspect, make repairs or improvements, supply services, or show the unit. Only in emergencies may the owner enter without prior permission from the tenant. Tenant use and occupancy. The Act covers only residential property. The tenant should use the premises for residential purposes unless there is an agreement to the contrary and should not conduct any illegal activities on the property. tenant's non-compliance. The tenant must comply with applicable laws and ordinances, use facilities and fixtures in a reasonable manner, avoid damage or destruction of the premises, and preserve other tenants' quiet enjoyment. If the tenant breaches the lease, the owner may give legal notice and force compliance. If the tenant does not respond within a specified time, the owner may terminate the lease and claim possession, rent owed, damages, and attorney's fees. The manager should read the governing state law very carefully to determine specific time frames to follow, what notice must be given, and when and how, when to go to court, and the time frames the judge will follow. All these time frames vary from state to state. Abandonment. A tenant who abandons a unit usually remains liable for the rent unless the unit is re-rented or the owner releases the tenant from the obligation. The owner is required to make a reasonable effort to re-rent the unit in cases of abandonment, if the owner seeks to recover rent for the unexpired term. Tenant remedies for owner's noncompliance. A tenant's remedies for the owner's noncompliance with the lease are also set forth in the Act. If the owner does not begin a good faith effort to remedy the breach, the tenant may terminate the lease after giving notice. The tenant is entitled to the deposit plus any prepaid rent and may also sue for damages and attorney's fees. Should the owner fail to deliver possession or illegally exclude the tenant from the premises, the tenant may give legal notice and obtain the essential services, sue for damages, or vacate the premises. Fire or casualty damage. If a unit is rendered uninhabitable by fire or other casualty, the tenant may give notice and terminate the lease immediately. If damage is partial, the tenant may reduce the rent proportionately. Case study: the compliance manager. June Wheeler is a brand new resident manager of a building built in the 1940s. As she reads through the files, she doesn't see any lead-based paint disclosure forms. When she brings this up with the owner, he has no idea what she is talking about. When she explains what can happen with lead poisoning, he says, well, if we have to do any painting, at least we only have to do it on the ground floor, because that is where the previous manager put the kids. Should June expect to see lead-based paint disclosure forms in the files of this building? Why or why not? What legal issue is raised by the owner's remarks about all families with kids being on the ground floor?